for delivery of judgment WPC 8464/2019 Saib Ali versus Union of India.
Me, please, your lordship. Lordship, I am praying for listing of a contempt case for tomorrow. In fact, it was fixed for tomorrow, lordship. But it is not listed in tomorrow's possible.
Can we take it up on Monday?
Any
Any difficulty in taking up on Monday?
Monday, lordship, my senior is also from Delhi, Ornab Chaturi, and the senior counsel is also there, all set to travel, lordship.
Okay. Okay, give it.
May it please your lordship. Lordship, may I pray for adjournment of item number 14 and 15. Senior counsel Mr. K.N. Chaudhary is out of station, my lord. We have taken consent from other side also, my lord.
No, I do not. What is the representative will be prayer made by the counsel for the appellant, applicant. The matter stands adjourned today. List on.
Can it be on 4th of August if possible, my lord?
Then please, earlier, my lord. Can it be earlier, my lord? Because there is a stay order operating, my lord, and my appointment is the promotion is happening with me. Can it be on Tuesday, coming Tuesday, my lord?
That is 4th of August, my lord.
Tuesday is 4th of August.
Lordship, in that case, it's okay. I'm sorry, I just kidding.
No, it's good that you wanted to object. Good. Okay.
Interim may be continued, my lord.
This stands extended from them. Yes.
May please, my lord. My lord, with the consent of the other side, I beg to mention item number 7. Adjournment slip has been circulated in the NAPA. Senior counsel, we are led by senior counsel Mr. K.N. Chaudhary. He is presently out of station.
Okay. Because 7 will go, then it will be 4 to 11. Entire thing will go.
Yes, my lord.
I am for 10.
4 to 11, my lord, is the connected series, my lord.
It goes, everything goes together.
Yes, my lord. Now, 7 is the leading matter, my lord, in the entire series, my lord.
The pleadings are complete in that
And
matter.
my lord, in item number 4 to 11, my lord, in 1 or 2 repetitions, my lord, the state is required to file their affidavit. It is pending, my lord. In the meantime, we will file our affidavit.
Okay. Since I duly represented, in respect of WPC 6172/2025, prayer for adjournment has been made. Stop. The counsel for the other petitioners have no objection to the adjournment being granted. Next para. The prayer made by understanding the understanding was for the Revenue and Disaster Management Department from leave is granted to file affidavit in opposition in the meantime. In those cases where affidavit in opposition have not been filed. Next para, the affidavits shall be filed by, yes, by when you will file it?
We will kindly grant me 3 weeks time, my lord. In the meantime, I will file my affidavit.
3 weeks. Give a date after 3 weeks. Affidavit shall be filed. You said the affidavit shall at least 2 days prior to the next date of listing. Next para list on so and so.
Okay. Interim may be continued.
Interim order passed release stands extended till then. 4 to 11.
4 to 11, my lord.
Okay.
Next.
24th. I'm so grateful, man.
Interim continue. Got your interim is continue.
Yes, Your Lordship. So back to mention for listing, Your Lordship.
Listing.
On last two occasions, it was left over, Your Lordship. She was in a legal detention, Your Lordship. Please.
For motion, item 1 with item 2.
Made to.
Yes. My lord is taking Mohanlal Bhattacharjee, my lord. Mohanlal Bhattacharjee, the proceeding. Yes. Lord, I'll be. So, my lord, in this case, my lord, there's a common opinion dated 30/4/2019, 2019, my lord, passed by the learned foreigner tribunal, Qatar first, in FT case, my lord, where both the brothers were declared as in foreigner, because of the opinion of the learned tribunal was primarily on this issue, whether the foundational document, that is the relief eligibility certificate, is correct or not. And in a manner, once he has found that relief eligibility certificate has not been established properly, the learned tribunal has not gone into the other documents as such. There is some observations are there. Well, before I proceed, my lord, what the documents which he is relied upon by the Mohanlal Bhattacharjee, my lord, apart from the fact that his father and mother had entered India and the relief eligibility certificate was there, he has given his, I'll be candid, my lord, one land revenue certificate, that is the Khajina receipt, my lord, of the where his father had taken some portion of land, and also he has submitted his school document. Now that school document, my lord, even though was issued at a subsequent point of time, but looking at the document, my lord can figure it out that the document was issued on based upon the school admission register. However, my lord, these two documents he could not prove by calling the relevant evidence, the persons who have executed those documents. Thereafter, my lord, there were certain other documents also, including the destitute home certificate that was actually issued in the year 2018. But the document shows that they were, after the death of their father, the entire family was taken to the destitute home, the central destitute home of Silchar Kachar, and they were residing there. So that document shows also that in 1978, from 1978 to till the date of the initiation of the proceeding, my lord, they were resident, because the notice which is also issued in this case, my lord, to the proceeding is addressed to the his locations at the destitute home, my lord. That my lord will see. Now, if my lord will permit, then I will take this honorable court from one, the one after the other document, if my lord permits, my lord. Yes. Okay. My lord, if my lord wants, shall I take honorable court documents, my lord? Yes, my lord. My lord, on that case, my lord, will come to page number 19 first, my lord. The typed copy, my lord, will find page number 17. The original copy, my lord, at page number 19, my lord. That is the relief eligibility certificate, my lord, was granted to the father of the proceedee, both the proceedees. That my lord will see on particulars of the person. It was issued in the name of Mohanlal Bhattacharjee, the father of the proceedee, my lord. His grandfather's name is there, my lord. And on the column number 5th, my lord, at the end of the page, my lord, it is written 25/7/2064. It is stated the date of arrival in India and place of entry. It is 25/7/1964 at Silchar. They were from Maulavi Bazar, Digod, Maulavi to Sylhet and ultimately to Silchar on 1964. Thereafter, my lord, they have also written the particulars of the family member who were accompanying him. That is, number one was Mohitlal Bhattacharjee, that is the father of the proceeding, and mother Nandan Bhattacharjee, wife dependent, it has been written. Thereafter, my lord, on the next page,
This document doesn't help you. The reason is very simple that this is merely a document for entry into India and you are entitled to relief.
my lord,
But that doesn't make you the citizen of India.
my lord,
This is not a document which is either under 5(1) A or D of the Citizenship Act.
my lord,
You just entered into India, that is there, but this is
my lord,
except for the formal entry.
my lord. My lord,
It doesn't help you anyway.
my lord, I'll just, so if my lord permits me 2 points probably, then my lord, I'll answer my lord's query, my lord. My lord, in page number 19, my lord, I forgot to show 1 point, my lord, that the reasons of transfer, my lord, page number 19, my lord, that what was the reason of migration? My lord will see that is for the communal riot, my lord, at page number 19, point number 3-4. My lord, thereafter, my lord, at page number 22, when the certificate was issued by the gazetted officer, the commander, the camp commander, he has the information which was present before him, and he has thereafter issued this certificate, my lord. Now, my lord, if my lord permits, then I'll,
Please continue, don't
my lord.
stop.
My lord, if my lord permits, then probably I appreciate what is falling from this honorable court, that the formal certificate of citizenship he has not taken, that, my lord, maybe EA, my lord, but what the proceeding was trying to establish, my lord, that his father has entered India on 1964, my lord. Now, how this certificate has been looked into, my lord, by the learned tribunal, my lord, that may be of little relevance, my lord, because learned tribunal has gone to this fact that as because this document is not available in the record room of the DC, the observation was made that, my lord, the document is not genuine. My lord, in this case, my lord, the Evidence Act 90, section 90, my lord, may be of some relevance, my lord. If my lord permits, then I'll just read section 90, my lord.
See, if the document is doubted as fake or not genuine, section 90 will never apply.
My lord, that is what, my lord, because the document was 30 years old, my lord, and it is.
No, a fake document 30 years old or 100 years old, how does it matter?
My lord, that observation, my lord, the fake, my lord, is based upon that simple observation. Let me just show that observation, my lord. In page number 43, my lord, straightway, my lord, comes to that page number 43, my lord.
You see, who took steps to call for that record?
My lord,
Who had taken steps to call for that record?
my lord, the tribunal had done that.
Tribunal of its own doesn't do it. Tribunal of its own has done it. Has the tribunal of its own done it?
Yes, my lord, the tribunal has own done it. And that is what page number 43, my lord, will be of some relevance, my lord. If my lord permits, let me just read the issue number 1, 2 lines, my lord, and
Yes,
relevant portion, my
please
lord.
continue. Don't ask us. Please continue.
My lord, issue number 1, the opposite party claims that the parents came from the East Pakistan and took shelter at Chandranathpur refugee camp on 1964. In this connection, the opposite parties exhibited one relief eligibility certificate. As per Exhibit 1, one Mohitlal Bhattacharjee, son of late Mohindra Bhattacharjee, migrated from village Gauhati, PS Maulavi Bazar district, Sylhet, the then East Pakistan on 25/7/1964 and seeks an assistance from government. One Nandan Bhattacharjee also accompanied him, which is shown as his wife. Exhibit 1 was issued by the Camp Commander Rehabilitation Center, Silchar, This exhibit was sent for the verification, from the authority concerned. Report received from the IDC Silchar dated 24/1/2019. In the verification report, it is stated that the name of Mohitlal Bhattacharjee have been searched for the purpose of verifying the authenticity of certificate. But the said certificate was not found in the preserved records of district record room. Hence, the report of the verifying authority dated 24/1/2019, it can be safely say that the exhibit number 1 was not issued by the lawful issuing authority, which means the exhibit 1 is not genuine. Therefore, exhibit 1 is wholly unreliable and could not be of any assistance with the opposite party number 1. My lord, I will pause here for a moment, my lord, and my lord will say that the observation which he is therefore made, that only because it is not been available in the preserved records of the record room, thus the inferences was drawn that the issuing authority is not genuine. My lord, that cannot be done, my lord, because the issuing let alone this point of genuineness, my lord, the issuing authority immediately cannot be challenged, because otherwise he should have checked out then other records, whether other records were signed by the camp commander. Be that as may, my lord.
You see, that is for you. Now let me ask you a question. You write to the you want to call for the sale deed of a particular case in respect of a transaction. You send the requisition to the sub-registrar's office. They said that it is not available. Now, will you make an inquiry that whether other records are available there? If you were there, you could have asked that to be done, that this report is not, we do not accept it. That objection you have not raised. Can that be an inquiry that this record is not found? So where are the other records?
Well, but can this a document which is older than 30 years old, is it not that the presumption will lie in the favor of the proceeding, my lord, in this case, my lord?
No, it must come from the appropriate custody.
It is his custody is appropriate custody, my lord, because he is the son and both are the son of the
You see, who has certified that this is a genuine document?
My lord, that only reason, my lord, it is not presumed to be not genuine is because it was not available in the preserved record.
The original records has to be called. You see,
My lord,
this record. You see, in this record, please look at the record. Particulars of persons migrating from East Pakistan on or after 1/1/1964 who seek assistance from the government. So it is only in that respect and nothing more.
my lord, maybe, my lord, what they were trying to establish, my lord, is then that they have traveled, they have came to India before 1971, my lord. This record only established to this fact whether they were present in India and thereafter lived within the territories of India continuously, my lord. And this is one of the, in my humble submission, of the chain of the documents, my lord, which shows that the parents were in India before 1971, my lord. And therefore, my lord, it could have been seen the presumptions could have been in his favor, my lord, because the initial burden of proof, my lord.
You see, your submissions is contrary to the effect of section 165 of the Evidence Act. If the court finds that that it is expedient to ask a question and or to make an inquiry, none of the parties can raise an objection. So therefore, the court had a doubt and it sent it for verification. It did not come. Now you could make a request that it is, if it is not in at the place X, please make inquiry where it is. That effort was not done.
My lord,
You see, there can be a situation where the document is at the place X. And after bifurcation or trifurcation of the district, it has gone to district C. So you can definitely ask for the report to be called from district C.
that my lord was not pleaded, so I am not pleading this ground, my lord, before this honorable court,
That's the problem.
because I will go
You
beyond
see-
the, what has been pleaded there, my lord. But there could have been, because the Lower Assam, my lord, and Kachar district, where there might be, my lord, there are some,
We don't know. It is, you
that is
see,
what the reason, my lord, I am
in
not,
every case, the lawyers are represented. How can we substitute our view that this could have been done, that could have been done?
that is, my lord, but what I am suggesting, my lord, very respectfully, my lord, is this, the document, only because it was not available in that custody of, or the record room, preserved records, my lord.
Mr. Pine, can you assist in finding this document? Rehabilitation certificate.
Let me try, my lord,
This should be,
the Kachar.
Mr. Issued at company commander Chandranapur,
Sundarnathpur grant, my lord. Tola Thoda, Dol Choda, my lord.
give a legible copy of this to Mr. A better copy than what is there.
In the record, it is the original copy is there, my lord, in that account.
No, we have only given proved in original.
The LCR is,
We are looking at the LCR only. I have a habit of seeing the LCR.
I'll try to get a better copy. I'll give.
এখানে কিছু নেই, না?
I'll immediately contact my lord.
This can help you. Now in Sribhumi. Now in Sribhumi.
Now it's Sribhumi.
That's Dhalchara. You see this Dhalchara page, this will come at page 21 of the writ petition. Dhalchara, so Dhalchara. Dhalchara is in Sribhumi, Nilam Bazar.
Valsara.
So you understand, Mr. Dev? If you don't assess the court, you may be
My lord, I will,
absolutely wrong in
So that I,
making a presentation.
that my lord, whatever is my lord, I can, I will assist my lord. this.
No, it's natural. You see, you will have to search where that area is. That's why we told you that original Kachar would have been bifurcated or
Bifurcated.
trifurcated.
But those grounds were not my lord, I did not wanted to start with this because. Now it is a Sribhumi.
Perhaps
Now it may be. Both the district either, my lord, let me see my lord, either both the district. And the both the district, Kasar and.
no. You see this. You scroll up. The first go up,
Yes.
No, go up. not down. Yes. Now here you will find Dhalchara. This Dhalchara is a forest village falling between Kachar and
This look.
Hailakandi.
20 kilometer from Nilam Bazar and around 20 kilometer from Karim.
So it is in between. It's a forest village. So therefore, now we're presuming that since it is Nilam Bazar, it is Sribhumi. Just find it out.
Both.
Kachar, they say it's not there.
Yes. Village info document. That's in the wrong.
As per the counsel for the petitioner submitted that the relief eligibility certificate within bracket exhibit 1 was rejected by the learned tribunal on the ground that the said document could not be located at the office of the district of the office of the then office of the deputy commissioner, Kachar, Silchar. Next, under the circumstances, we request the court requests the Mr. J. Pangal understanding also for the border and FT matters to make an inquiry as to where the said document will be located. Possibility as well, possibility of being located. Where there would be a possibility of the document being located. Next, we've done it. Standing counsel for the body and FT matters is permitted to send a downloaded copy of this order to the competent authorities We are going to seek instructions. Next, matter stands adjourned today. Before that, you say the learned counsel for the petitioner shall provide legible copy of the Annexure 1 to the petition to the learned standing counsel for the border and active matters in course of the day. Next para. List on how much time?
At least 2 weeks, madam.
Give a date after 2, make it 3 weeks. And in the second case of this second case,
In the month of first week of September, madam.
okay, in the second case, same thing.
Same thing. Both of the brothers, madam.
Okay.
First week of September.
So there is second order in the second case, same thing. Okay, give a date.
Upgraded item 16 for orders.
But Mr. D. Mazumdar is appearing for the state in this meeting. He is before court number 16, madam. He's on legs.
Okay.
Well, before the petition of the IA and the other side submits your lordship, I am appearing for a writ appellant. The state's service of notice upon all the respondents are not complete, your lordship. And so we have taken steps 3-4 times, your lordship. Certain addressees already left the earlier residence. We don't have their new address. So may I pray for substituted service, your newspaper obligation? All the postal remarks for respond number 26, 44, 52, 57, and 63 came with the endorsement left. So addressee left their places and we don't have the new address.
You see, that will be a difficult proposition. We'll tell you why.
Lordship.
You see, every day in the newspaper, we find some summons here or there asking persons to appear before the courts and tribunals.
Lordship.
Correct. Every day in the newspaper, some people will find it. Have you ever read it?
Never.
Never, because it doesn't
True.
matter to you. So therefore, if they have left and we don't make any attempt and we make a substitute service, we have to
Lordship, order 5 rule 20.
Yes.
Apologize, I did not bring the CPC, your lordship. Thank you.
I use CPC everywhere, even in
Lordship, I should have also brought your lordship.
even in bail, I use CPC.
Lordship.
What is it? Please read. We'll refresh our
I am
memory.
on the other part, or that for any other reason the summons cannot be served in the ordinary way.
So therefore, you see, these are two, both conditions are not there. First condition is that he is avoiding service.
Yes, that is not here.
That's not there.
Perfect case, yes.
So therefore, the second is that if it is for otherwise could not be served.
Yes, we tried to serve it 3 times, your lordship. So on that ground itself, if your lordship permits.
No, but there will be some affidavit somewhere to bring it to the notice of the court.
The Lawazima order there, your lordship. If your lordship permits, then I can take one more chance, your lordship. I can take instruction from my client regarding their whereabouts. The only thing is all the responses, they were implemented.
There is no difficulty otherwise.
Lordship.
But the problem is that once service is made and accepted, there are other difficulties associated with it. Number one, any order which is lawfully passed, but is passed against a dead person, would be a nullity.
Yes,
So let us say in this 10 people on whom notice is required to be served, one has expired.
in fact, one such incident has already happened, your lordship is right, your lordship. So
Then that goes to, therefore we have to.
then
be
we
very-
will also not be aware that they need to be substituted and the case will be abated.
No.
That I am aware, lordship. But we have sincerely tried, your lordship.
No, you see, have I doubted you? You
No,
are
no, yes,
bona fide, not. We are on the legal aspect of it.
Yes,
How far it would be correct in doing so.
that aspect I have also thought, your lordship, because then the substitution will remain pending. And technically, my case will be abated.
No, it will never abate. Your application is there.
Lordship.
It will be thus. I think, these are conclude. Do you have copy of any of the applications which are referred to in the impugned judgment and order? You have a copy of your judgment and order?
Yes, your lordship, in the recapitulation.
Yes. See page 3 of that judgment cost title. Respondent number 19 implemented by order dated 16/9/13 passed in this case.
Lordship.
So do we have, can you produce us before us this copy of this missed cases? 1952. In the other, it is serial number 20. It is these two cases. Then 21, another case.
Yes, your lordship.
So these people were added. Correct.
Yes, as per direction only, all the
No, I
respondents.
understand, but who filed this application and what was the address disclosed there?
From, that is the address which is here in the judgment itself, your lordship. Same address,
That's why we wanted to confirm whether it is correct or not.
lordship.
Can you produce us before us the
I
copy
can do
of-
that, your lordship. Even if I don't have, I can procure the certified copy and save it here.
No, you don't need to do that.
Or take it from the court record, your lordship, I can do that.
Your Lordship, I'm sorry to interrupt.
We'll then call for the records of this WPC 6498. Yes, you wanted to say something, Mr. Fukan?
Yes, my lord, I appear for 65, 67 and 68, my lord, who were originally not impleaded in the writ appeal. And subsequently, your lordships were pleased to implead us after we moved an application for impleadment. Now, my lord, we have filed an application, my lord, which is the new IA, my lord, which is listed today. Now, my lord, in that we have raised a concern regarding an encroachment, my lord, in our land. Now, because there's an interim order in the writ appeal, status quo as to possession and status quo also on revenue records, we have not been able to carry out our mutation. So that's the larger issue, my lord. But now in the interregnum, what has happened,
Mutation, we told you earlier also, mutation will never happen.
my lord? No, I'm not on that, my lord. So therefore, what I'm
But
trying,
no, but if you have encroachment, what can we do in a writ appeal? You'll have to defend your position in a civil court.
my lord, what has happened is this is actually in a sense a fight between, my lord, the temple and the state, my lord, pertaining to the settlement that happened and that was challenged before the learned single judge, and the learned single judge was pleased to reject it primarily on two grounds, my lord, that there are disputed questions of fact, and second, my lord, there's huge delay and latches, and they have also not made substantial prayers pertaining to the acquisition by the state. Now, my lord, in that there was a direction that was given, my lord, where the learned single judge said that the state claims that the retainable area is known to them, the authorities. So therefore, based on that retainable area, whoever are encroachers, those encroachers should be evicted. Now, my lord, that's a direction which cannot in any way adversely affect the appellants, my lord. That is clearly in their interest. So that is one concern, Miller, that direction should have been implemented. The complete status quo that has been granted has not helped anybody's cause, Miller. But another aspect which I am trying to draw my Lord's attention to is that just like me, there are many landowners who are now caught in a crossfire in a fight which has nothing to do with these landowners. Because now I am not able to carry out my mutation and do nothing with the property. I cannot even avail a loan, raise no construction whatsoever. Now, instead,
No,
what is
because
happening?
you see, we have addressed you on those grounds earlier. Correct.
Well,
We have referred to why we did not, why we were not inclined. We gave you our reasons.
well, my IAs are pending, so they have not been.
We understand, but
yes.
in this case, you see, it's so far as we are concerned, it's a simple issue. If you have a dispute with regard to possession, then you are free to move the civil court, because in the writ appeal or in a writ petition, the directions for the sort of injunction which is granted in a suit cannot be granted.
I agree, I bow down completely. But the interim order, Millard, which has been operating since 2003 when the matter was pending before the single judge, and thereafter, Millard, another interim order which the learned division bench has passed, in view of that, no civil court will be inclined to interfere, Millard, with all respect.
Where is that, in which IA is that order?
Millard, your lordship's order, your lordship will find, I'll just indicate the date in the writ appeal, Millard. If your lordship takes up the IA, Millard, which is listed today, IA 2068 of 2026.
Yes, Mr. Fugan, you are referring to this IA 2068? Yes. You are muted, I believe.
I'm sorry, Millard, am I audible? Millard?
Yes, now you are.
I'm sorry, Millard. Millard, this is IA 2068. If your lordship could kindly come to page 47, Millard. This is the 17th February 2023 order, Millard, by which the writ appeal was admitted.
Yes.
Millard, I'll just come to the second paragraph. Learned Senior Counsel, Mr. D.K. Mishra,
You see, Mr. Fukan,
Millard.
this is something which we have addressed you earlier. In a different bench, we have told you why. We have given you reasons. Correct?
Millard,
You see, the issue of retainable land, when you come to section 3, is land which is reserved for the deity. Therefore, the land could not have been transferred. That is why we said that the land which you have acquired will never be mutated in your name.
Millard, but may I just show your lordship, subject to your lordship permitting
You see,
me? May I
we are-
show the... Yes.
You see, that doesn't go anywhere unless we hear it. And
It has
this
to be heard.
somebody-
I bow down, Millard. I can't get this
this-
as an interim relief, Millard. I bow
can
down.
be way of an interim relief.
I bow down completely, Millard. But what the interim
Now-
prayer? Yes.
But the problem is that Mr. Sharma here, in this case, the service is not complete.
Millard,
So we're still at the same stage. Mr. Saikia is also sitting here. Mr. R.C. Saikia is also sitting here. But unless this service is made,
Millard, may direct publication because we are, as landowners, Millard, we are suffering because we've not been able to do anything with our lands,
that's what we are deliberating.
Millard.
Yes.
So if Millard, publication can be directed or Millard, because the addresses are not complete, that's why the service could not be completed.
If I may interrupt your lordship, regarding the query your lordship has made, this IA, I can just verify whether the addresses of the
No, we'll
IA.
call for that record. Instead of
Yes.
dealing the matter, we call for the record of that
Lordship.
writ petition,
Lordship,
so that everything will be before us.
lordship,
We'll examine.
yes, your lordship.
We're getting it listed on 5th of August.
Lordship,
We are calling for the record of this writ petition. So we'll come to know about the addresses. Then we'll pass orders for
either phrase step or substitute.
either first steps or substituted service.
Lordship.
Millard, could it be 4th or 6th, Millard, subject to convenience?
No, because we'll have to first pass an order of service of notice in Mr. Sharma's application that service is incomplete.
Right, Millard.
So we are not putting up for hearing on that day.
No difficulty, Millard.
Pass interim orders and orders for service. We just have to look at the records.
No
The
difficulty.
implementing were made by various IAs. Those IAs are not with Mr. Sharma at the moment. See, what is the representative? Mr. P.K. Sharma, learned counsel for the appellant in WA 53 of 2023, praised for substituted service of notice on respondent numbers 17, 18, 26, 44, 52, 57, and 63, right?
Lordship.
Full stop. It is submitted that the addresses are incomplete. So therefore, court is inclined to call for the record of WPC 6498 of 2023 to ascertain the addresses as as available in the record, in the said record. Thereafter, orders will be passed for effecting service of notices on the respondents referred above. Next paragraph.
Lordship, may I just show one aspect, my lord, from my
Yes.
IA, my lord, which I wanted to show, my lord. The same.
Just a moment, let me complete that order.
I'm sorry, my lord, I'm sorry.
List the matter on 5/8/2026. Yes,
Lordship, can it be on 6 instead of 5?
that is a Thursday. We are reserving those
Got-
days for order, for hearing. This is in miscellaneous orders. We'll pass it on the the regular motion day.
Lordship.
Yes,
Your lordship may just have my IA again, my lord, IA 2068 of 2026. My lord, may come to page 25 in this, my lord. And this is pertaining to the encroachment which I was mentioning. Where GMC acknowledges, my lord, the merit in my complaint regarding encroachment. This is dated 28th April 2026, my lord. My lords have it, page 25.
but it says government land.
Yes, exactly, my lord. That's my lord, the government land. Basically, what they have done is they have encroached into the road and they are touching the construction through encroachment into my land, my lord. So this is something which needs to be looked into because because of the status quo order, my lord, that there are people there in the locality who are taking advantage because we can't raise any construction in our land. So vacant land, my lord, it's only an invitation to encroachment, my lord.
We take notice of what you are submitting, but the any tinkering with the order of the status quo will lead to the opening of a Pandora's box. The reason is that it will be beyond our since this land refers to the entire Kamakhya land, and there are not one, there are hundreds of persons.
My lord.
We'll have a floodgate of interrogatory applications telling us that this is my land, that is their land. 5 inches they have encroached, 10 feet they have encroached. This will be beyond our scope of their adjudication or writ petition. The long and short of it is that once the land is a Kamakhya land, then apart from the land which has been acquired under the 59 Act, all other land would be a retainable land of the temple. You would not derive any title at all. The reason is Section 3 very clearly says that this retainable land is not to be sold or alienated. So it will have a ripple effect. Whatever order we pass will have a ripple effect on your title, whether it is under challenge or not. Once we decide this section 3, retainability of the land, then the land revert back to the deity of the Kamakhya.
My lord,
That
but
we have
the,
addressed you earlier also.
yes, my lord, but the learned single judge clearly records that there was no challenge to the acquisition. So section 30, there was no relief sought qua section 3, my lord.
That is an operation of law.
That's the finding, my lord, which has not been set aside by your lordships so far. All that I'm saying today is, my lord, all that your lordship may pass some direction so that the authorities may act on these complaints, because that will also be in the interest of Ma Kamakhya deity, my lord. Because if it's deity's lands also, then also, my
No,
lord,
that is not open for you to tell. The reason is that you are claiming that it is your land. You don't refer this land to be a land of the deity because you purchased it.
my lord, all that I'm saying is, this is a subject matter of the writ appeal now. All that I'm saying is, my lord, let no encroachments be there. If encroachments are pointed out to the authorities, and the encroachments, the authority has also taken a prima facie view, my lord, that it is happening in the government land, at least, my lord, that should be taken care of by the authorities. This is a letter of April 2026, but after that, they have not taken any steps.
Sorry, Mr. Phukan, that is unacceptable.
Because even if it's deity's lands, my lord, if encroachments are happening,
Oh, no. It's, you see, your proposition is not acceptable. The reason is very simple. Number one, you claim as an individual having ownership of the land. This is not a public interest litigation where you want to protect the government land or land belonging to the deity of Kamakhya. This is not a public interest litigation. It's a private interest litigation. You are saying that your land has been encroached.
my lord, may I say this? My lord, your lordship rightly pointed out that this will open a can of worms, my lord. But if your lordships don't intervene now, my lord, it will open a larger can at a later stage. Because
No, status quo is there. If there is any encroachment beyond this order of passed by this court in the writ petition, we can undo everything. No construction which is in violation of the order of status quo would be sustainable.
my lord, but at least the encroachments that are happening now, my lord, that should be stopped, my lord, because I'm not
We
able
consider
to.
that on 5th. That let me discuss that.
Because the early disposal of the writ appeal will take care of everything, my lord.
Who's appearing for GMDA? Is GMDA represented?
Lordship, there is one more aspect, your lordship. This is compliment.
GMD is not a party here.
GMD is a party, your lordship. There is one thing, your lordship. GMD is 16, respondent number 16. And 17, your lordship, Commissioner and Secretary to the Government of Assam, GDA. At that time, it was known as Government Development Authority, your lordship. So, Metropolitan Ward is not there. So, 17, or whoever is appearing for 16 can also appear for 17.
No, then there will be a requirement of amendment in the respect of 17.
Your lordship, I am also thinking.
It is housing and urban affairs department now.
Yes, earlier it was Government Development Authority. It no longer exists. So,
Mr. Mazumdar, as the law officer of the state, you can appear for, we can direct the constitutional amendment of the respondent number 17, because day before yesterday, our Advocate General made a submission that the authority for the for this municipalities and municipal corporations is the urban development, housing and urban housing and urban development department. So 17 has to be amended. And then through your assistant counsel, you can appear for 17.
And 16 also. 16 is GMD.
16 is GMDA. No, 16 has a counsel. I don't know.
Standing
who is-
counsel is there.
You are there. Mr. Mr. P. Nayak. Just give a scroll for Mr. P. Nayak. SC GMDA. Another paragraph. The learned counsel for the appellant has pointed out that in the meantime, the nomenclature of respondent number 17 has the nomenclature of the department representing respondent number 17 has undergone a change. And the concerned department is now housing and urban development, housing and urban. What was the name? Housing and urban? Housing and urban development department.
Housing and Urban Affairs.
Affairs, yes, affairs. It will be affairs. Housing and urban affairs department. Next, accordingly, the registry shall carry out the necessary correction in the cost title of respondent number 17, which will now be read as follows. Next paragraph, 17, inverted comma 17. The state of Assam, comma, represented by it will be the special secretary.
Commissioner and
no.
Secretary.
No, it's not commissioner, principal secretary. Just find out. Principal secretary to the government of Assam, comma, this for Gauhati, 5, 781005. Stop. Next para, Mr. D. Mazumdar, an additional advocate general for the state affairs for the state respondents, comma, his associate counsel shall accept notice on behalf of the substituted respondent number 17. You are the appellant? Mr. Sharma, you are the appellant here?
I am the applicant.
You have to give a copy.
Lordship, I'll give it. It's
A copy of
Special
the,
Chief Secretary.
a copy of the memo appeal and interrogatory application be provided to the assisting counsel for the additional advocate general within 2 days. Yes, Commissioner. So Commissioner Secretary. Commissioner Secretary. Thank you for your assistance. Okay, next one is on 5/8/2026. And in this IA also pass a separate order by Mr. A. Fukan, Learned Counsel for the applicant who appears through video conferencing. All the respondents are represented. Next one, as the connected appeal has been adjourned, the matter stands adjourned today, list again on 5/8/2026 for consideration. We will consider on that day, 5/8.
Obliged.
obliged, sir.
Mr. Mazumdar, Mr. Mazumdar, in fact, here your presence would be on the next date would be more essential because Mr. A. Fukan, he's saying that there are encroachments going on. And in view of the in order of status quo, he says that the encroachment is rampantly being carried out. So you as well as Mr. Nayak, you have to, your departments, you'll have to tell us. And we'll just tell you because did you hear what I was making a statement? Did you hear that? Okay. I'll just tell you what I the thought which I had. You have the in the last part you will find that this is what you call that. Yes, 59 Act. You have a copy. Now see section 3.
Section 5 speaks about the retainable area.
Section 5, I'm sorry. Of this 1959 Act, Assam State Acquisition of Lands. Yes. Reasons including so and so shall effect from the date of vesting shall entitled to retain possession of. Correct? So this
The proviso is important, Your Honor.
this what can be retained is again one, free of revenue all such lands which on or before the last day of Chaitra 1365 BS. This is Bengali Sambat. Bikram Sambat, I'm sorry. Where in the ownership of the institution and were actually occupied by its constructing building and raising orchards, the rover gardens together with the compounds appurtenant thereto and all lands reserved for the resident devotees of the essential purposes. Proviso, provided that the right of ownership or possession of such land shall not be transferable or alienable. Correct? Now, we are referring to this act, what do you call this act in 59. In 59, since we have not seen those days, 59, I was born a bit later. In 59, people used to say that my land is there till that tree.
Okay.
That was the physical possession people had. There was no demarcation, no boundary, nothing. People would say that my grandfather put a Tamil tree, that is the Tamil tree and that is my land. That is how people used to know the land. Now, the land of the deity in Kamakya, what was acquired and what was left as a retainable area, that document I have never seen. There is a second aspect of this. This is something I told Mr. Fugan earlier also. This is something I have recollected after 7 or 8 years. In a single bench, I dealt with these matters and the arguments made there, I recollected somehow. In that writ petition, it came out that the records of the land revenue records were called for. And it was available before the court, and thereafter, when the matter was disposed of, it was returned. And the office of the deputy commissioner says that we have not received it. So the original land revenue records of the village Kamakya is lost. After that, from general idea we have, there should have been 2 to 3 settlement process. Those settlement processes were never undertaken for the village Kamakhya. On the ground that the records are not available. But we have no authenticate data about this. These are the only submissions which from time to time the government advocates made us, and somehow I retained it. And therefore I may be wrong.
No, your lordship is absolutely right, your lordship. They always refer to an old Jamabandi. That is our case, your lordship, which was not before it.
So now what will happen, once there is a land which is retainable by the deity, that land would be non-transferable. And therefore, any mutation which takes place of the land which belongs to Kamakhya would be an illegal transaction.
Lordship.
Now, nobody has disputed Mr. Fukan's sale deed or things. But it is by operation of law that when we take note of section 5, then whether the transactions are good or bad, that is something we like to address. If it is outside the scope of the acquisition, can the court give its imprimatur to a transaction which is otherwise hit by the proviso to section 5(1)? That are the broader issues which will come to, which we will have to address. These are not neither the pleaded case of any of the parties. I will have to tell you that these things are not the part of the pleadings or the process till now. So this is something which is beyond the scope. For the timing, it is beyond the scope of our of the adjudication right now. But the question is that if there is something which the law provides for, can the court be a silent spectator to that provision of law? It is in this aspect I am asking you to make your submissions.
Lordship, I can't hear Mr. Majumdar. I would be grateful if he can speak on the mic, Miller. I'm grateful, sir.
And another aspect, Lordship, I just think this may be quite relevant to what your Lordship has indicated. Lordship may just have a look at the prayer made in the writ.
But here, your lordship is limited.
In the writ petition,
My line starts in the memo of appeal, starts from page 65. Page 111, the prayer portion starts.
yes.
In the premises of proceed, it is prayed that the Honorable Court be graciously pleased to admit this petition. Call for the records pertaining to the preparation of the original Jamamandi in 1973 and the duplicate register in 1987, and the chithas along with the original Jamamandi and duplicate register and the chithas, and the records pertaining to the current resettlement operation which is in progress. Issue rule calling upon the respondents to show cause as to why the original Jamamandi and duplicate register and current resettlement operation, along with all steps in furtherance thereof, already undertaken by respondent number 3, be not declared as null and void and illegal in view of the non-demarcation of the retainable areas of land, and be further pleased to issue a rule in the nature of mandamus calling upon the respondent number 3 to refrain from proceeding and further with the resettlement operation, if any, in any manner whatsoever, and or to issue any other appropriate order or direction upon hearing the parties as may be pleased, etc. So this was the prayer.
And in course of deliberation, manner, I remember possibly on the single judges mentioned also somewhere, the question key, if the retainable area is to be determined today, it is not possible today. Things have changed. Where was the kitchen? Where was the garden? If your lordship goes to the Acts, as your lordship has just now shown, it says that construction of building and raising of orchards and rower gardens together with the compounds, that position in 1959, whatever obtained in 1959, today it is not possible. That this came in course of deliberation. Then why have you come so late? You think Ross want to say that the retainable areas are not retained, not allowed to be retained. Today, where is the scope after 1959, my lord? It's, I think, more than 60 years.
No, but you see,
My lord, correct. If the records are there, if the records indicate that these were the retainable areas, this was the demarcation, then its matter is different. The petitioners have
we
come.
understand, but you see,
I'm just indicating what happened in course of melody.
no, you're absolutely right.
Correct.
We appreciate that. But you see, what can be done is the government with its all magisterial powers can still ascertain which are the constructions which have come up or after 1959. Correct? That is quite possible.
That is possible.
Now, all those constructions, be that as it may, let it remain whatever is the position, whatever transactions have taken place, let it remain for the time being.
Right.
What prevents the government to complete the exercise of settlement process to find out the current position and then fill in the gaps?
Madam, in fact, towards the end, before the actual disposal of this writ petition matter, one affidavit was filed, whether it is on record or not, matter, on behalf of the deputy commissioner, that if a direction is given, we will do the exercise. One affidavit was there. At a later stage, it was filed.
Page 224 upon the committee.
224, filed by deputy of page 258.
We have seen your argument, which is at page 281.
Right. Yes.
I think this is recorded by the learned single judge also at page 287, the point which.
Yes, we have seen that. We'll come to that. It starts from 286.
Right.
Though it is pleaded that entire Nilachal Hill and Durga Sarovar Hill are contemplated to be retainable area, this code is not in position to determine the retainable area in the present days. So therefore, judicial adjudication can't be made. But this does not prevent the state from doing that exercise and then do the back calculation. Any transaction which takes place after the acquisition took place would be void ab initio.
Yes. Any construction, any transfer, anything, my lord, within the retainable area will be illegal.
Yes. So therefore, if the government wants, it can still determine. It depends on the will of the government now. If you have a will, you will have a way.
This is what I want to point out. Towards the end, an affidavit was filed saying that if the directions given, the deputy commissioner said, we are ready to do it.
One more aspect, your lordship, if section 5 and section 6 are read together, after the retainable areas are demarcated, the other land will be vested in government, your lordship. So in either case, it will be either the land of the deity or the government.
Page 228, Lordship may kindly see. Page 228, paragraph 14. This is a part of.
Just a moment,
Madam.
just a moment.
So
Hello. You have this way. But this is here. No,
So it's not. You are away.
you-
You have away.
no. You petrol চলি আছে, that is 65. Petrol last week কি হলো?
সুন্দর খুলে আমাকে হবে। সুন্দর তার বাড়ি ম্যাক্সিমাম
31 তারিখ, 17 তারিখ হলো মনে হয়।
সত্য লাস্ট ডেট
হুম।
হবে। বিল 15 কিলো হবে। বল এপ্রিল মাস এপ্রিল সেকেন্ড এটা
মাসে
15 17 লিবিয়া হবে পসিবল
possible হবে। আমার নিউজ 28 হবে। মানে পেট্রোল আমার 14 দিন থাকে না, 14 কোথাটা 14 days।
কিন্তু খুব ভালো আগে আসলে জানি ম্যাক্সিমাম এক বহাগ 14 বা 15 বা 16 17 বছর
17 কি হবে? ঠিক হয়েছে আপনার 11 এপ্রিল 1959 last day. Yes, page number.
I wanted to point out to Lordship page 228. So this is a part of the affidavit filed on behalf of the Deputy Commissioner, my lord. It was page 228 now.
228 para,
Para 14,
para 14.
yes.
Now, you see, it refers to only demarcation of his land. It doesn't say about the entire land of these two villages of Durga Sarovar and Kamakhya.
No, my lord, then you also will kindly turn to page 293, the property part of the,
You see, the problem here at paragraph 14
My
is
lord.
somewhere else. We'll tell you why.
my lord.
Yes, Ane. Nine, it will be 6 or
11.
23.
Yes, section 23. Regulation. Section 23. Section, they call it section. ma'am. Yes, yes. Regulation, but then otherwise provisions are mentioned as section somewhere. Yes, ma'am. Madam, procedure in case of boundary dispute. Ma'am. Yes. Yes. In fact, my lord, your lordship is correct. The issue is basically what should have been to ask for a direction that let us have a survey or an attempt to find out the retainable area of the. No, my lord, what I am saying is, my lord, no, but that's what I'm saying. It's a writ petition. Difficulty is that in the writ petition, if the lordship goes to the contents of the writ petition, it is more in the nature of an individualistic grievance. Whereas my lordship is, what your lordship is saying is for the purpose of demarcation in order to find out the retainable area of the camp. There is slight difference in the, that is why their approach itself was whether that particular limitation was correct or not. That's what I'm. That is the real issue. Right? My lord. My lord, may I kindly see the direction issued by the honorable single judge. 293. Possibly there is some indication. Page 293, para Roman 11. And page 293, I am referring to. Roman 11. While holding as aforesaid, in fact, in the above paragraph, the writ petition has been dismissed. Now, the honorable judge says, while holding as aforesaid, this court cannot be oblivious of the fact that submissions and alternative arguments may advance by Mr. Chaudhary Land Senior Counsel that it is a bounden duty of the state to protect the land of the deity as has been retained. Mr. Majumdar Land Irrigation AG has also endorsed the argument advanced by Mr. So-and-so, Learned Senior Counsel, regarding the application of Chapter 11 of the Assam Land and Revenue Regulation 1886. In view of the aforesaid and considering the statement of the Deputy Commissioner that it can still identify the retainable area, this court is inclined to direct the Deputy Commissioner to verify the retainable area already determined belonging to the deity of Sri Ma Kamakhya under the Act of 1959, and that if it is found that the retainable areas earmarked are under encroachment, the Deputy Commissioner shall evict those encroachers from the retainable area by following the provisions of Assam Land and Revenue Regulation 1886 and hand over such land to the petition number 2. There shall not be any bar by virtue of the judgment in grant of mutation and settlement, etc., if otherwise permissible under law relating to the land beyond the regional area. So that direction is there, my lord, but they have filed an appeal that could not be undertaken. So this is that. If you can stay,
How the government has appreciated this order, the operation of this order was never stayed. What is said that the status quo be maintained.
So lordship, if your lordship clarifies that, they will go ahead, my lord, because status quo, in the presence of a status quo order, whether it will be proper on the part of the officer to start an exercise, but that possibly.
No, demarcation, that operative part of the demarcation was never stayed.
And lordship, if your lordship indicates and clarifies this, then they can always alert.
It's not required, I think.
It is required in my humble submission when a status quo
No,
order
then-
is a very vague and over.
No, you see, then what we are thinking aloud
Violet.
is that the state can always file an interlocutory application for a clarification as to whether the status quo will not affect the government to do out the settlement process or to find out the retainable area.
And the basic thing here, direction is for find out the retainable
So
area.
therefore, you see, first you will determine the retainable area.
Yes.
Only thereafter you will give notice for the eviction and all.
Yeah.
So this, so far as we understand, there is no stay operating. But if the government thinks that there is it might be a violation of the order of status quo, please file an interlocutory application by 5th. Will pass an order.
My submission will be, since your lordship is now examining the matter, lordship may just issue a clarificatory observation.
We understand, but you see that the state is not doing it for that understanding. Let that be got on record and we'll pass orders. You see, the problem is that this, so far as in this case, the court should normally not pass orders which are not within the scope of the intra-court appeal. The intra-court appeal is by Mr. Sharma.
Yes, lordship.
And here, if we give a order which is favorable to the state,
No, it's not a question of, the issue, therefore I wanted to differentiate. The issue with which, the grievance with which the writ petitioners have filed this writ petition is slightly different from the issue your lordship is showing concern about.
yes,
So if that is the position, your lordship can always, in an exercise of power under Article 226, grant a pass an order.
on a formal determination, we can do it. But
In fact, my prayer is pending, my lord, in this regard.
interlocutory application, without an interlocutory application to pass an interim order, that is something we will consider on that, on 5th.
Your lordship is disposing of the whole matter in the next week, lordship can pass a final order. It will be better, my lord, after so many days. In the next week, lordship may dispose of the whole matter, my lord.
We'll try to.
My lord.
In fact, my lord, I'm sorry to interrupt. My lord, the prayer, there is a specific prayer regarding implementation of Direction 2, which your lordships just saw, regarding, my lord, removal of encroachment. There's an IA, my lord, which my clients had filed, my lord, which is listed, my lord, also.
Just remind us on 5th, we will pass orders then.
Very well, my lord, obliged.
Just remind us of that
Obliged, my lord.
on 5th.
With my learned friend, Mr. Dilip. But my case has been pending, the case was filed only in 2003, more than 20 years. So your lordship can dispute the case in the next week. Because if the order is a little bit modified, directing the DC to carry out the order immediately, he will do it, time bound may be given.
We will try to. This is something we can't assure you right now.
We kept respect.
We can make an effort.
And madam, despite dismissal of the writ petition, there is not seen. There was anxiety shown by the honorable single judge, and I also considered it. Yes, in my submission is also mentioned there. Let there be an effort to find out the written.
Regarding this aspect, I can also obtain instruction and I can ask my client to, because
You see, this.
determining the retainable area, if the government is willing, then we do not have any objection.
That my
It's not a question of willing, there is a judicial order.
Yes,
order is
That-
there.
The judicial order, Mr. Mazumdar says that because of the.
I
status quo
also think that,
operating.
yes, it is.
that is regarding the status quo over the.
He says that maybe perhaps the authorities are finding it difficult that
Fine.
when there is an order of status quo, the
Better than
determination of land.
the matter for final disposal the next thing.
We are all committed to mark Amit Shah.
Because the interim order says status.
No, we don't know, that is not the reason to decide the matters. If we decide on the basis of faith, that could be a wrong approach. We have, you see, you have not taken an oath of how would you conduct yourself, but we both have taken oath that we will do it in a fair manner and without, what do you call,
Fear and favor.
without fear and favor.
I think that my 7 minutes only, do not.
We are- As a council member, we are only concerned about the bar council rules. Beyond that, there is no.
The other considerations may not come when we.
During the pendency of this case, some photos are left for heaven. Their sons and daughters' names are not native. That is, and they are far away from government. Far away.
Let us see, there's something in the
But
near.
I think this was the most necessary manner. By giving the modification of the order.
You can always pray that when there is a litigation, the litigant should not die. That's where you can go and make,
Beyond that, nothing can be done.
nothing is.
Obliged.
Your lordship may kindly keep both the IAs, my lord, on the same date, 5th, my lord. There are two IAs.
Upgraded item 13.
Item 30 also similar, supplementary item 30 number 30.
Item 13 and 30, my lord. We have filed the affidavit today only, my lord, today morning. We have started copy, my lord, already. We have already filed killing. On behalf of the SP. Yes. My lord,
Last order notice 20 to 7.
yes. Yes, everything is given there, my lord. In fact, my lord, up, yes. Up. Yes. That's that. My lord. Take it out.
This item 13.
May I please your lordship? Lordship, in this case, I am agreeing on behalf of respondent number 9, item number lordship 13, and respondent number 10 in item number 30 lordship. So today lordship, I am going appearing lordship, I may be allowed to 2 weeks time to file my application.
Not 2 weeks, because you see here it is the respondent by 9 and 10 who did
9
the
and 10
mischief.
lordship.
Who did the entire mischief.
Member of Foreign Tribunal lordship.
He is the main mischief maker.
Lordship, as the allegation head lordship. So lordship, that's why lordship would be kind enough
Because you see, the
to
person has
grant me
been
at
sent,
least 10 days time lordship.
the person has been sent to, 10 days is okay. Because the person has been sent to Bangladesh in a manner which we don't appreciate.
Okay, that is just allegation is level, lordship, in that aspect.
that is the attitude, then he does not deserve to be there. He should have come from there to BSF. He should do duty for the country, not as a judicial officer. Unbecoming. You see, how would you like if I reject your bail application and then say that the place should be here, and then when I reject it, you will be taken into custody? Would you like it?
Yes, if it is true lordship, it is not acceptable. But lordship, I will try to the affidavit of person is clarifying my claim lordship.
You did not want to give me 2 weeks. 10 days is okay. All sides are duly represented. Mr. P.P. Datta from Council enters appearance for respondent number 9. And in the other case, it will be 10. And praise for and is granted 10 days time to file affidavit in opposition in the matter. So, affidavit shall be filed by how much time? 10 days will be. Shall be filed by 10/8/2026. This is on 11/8.
So 10 lordship on 10.
On 10. You will give it, especially when 11/8/2026. Sure, you, before that, you also say that we filed within 10/8. Just stop there. Next para. Mr. J. Payang, that is standing counsel for the FT and border matters, is something that the respondent number. Respondent number. Respondent number.
Yes.
Who is filed the affidavit?
SP Gauhati Police. In my item, lordship, it is item
No, in this item 30. Who is
30,
filed?
respondent number 6.
Item 30 also respond number 6.
That has filed an affidavit in opposition, and in the other case it is.
Respondent number both 6.
Both cases filed, opposition in the matter. They said the tag with the record. Next list on 11/8/2026.
Obliged.
Next date 11/8.
11.
Obliged.
Both orders they are passed together.
Item 30 also.
30, both.
For admission, item 3.
Yes.
My lord, impugn judgment starts from page 65. And my lord, the documents relied are dealt from page 67.
Yes.
Lord, may I come to page 67, my lord, paragraph 6.
Yes.
May I read, my lord? The procedure of filing written evidence in the form of affidavit. The contents of his written evidence are almost same with the contents of his written statement. He has produced 13 numbers of documents along with his written evidence in support of his Indian citizenship, which are carefully scrutinized as discussed here and there. Exhibit A is the supply card for purchasing kerosene or bearing number so and so, soon to be issued on 17/9/49 in the name of MD A. Mannar by Supply Superintendent Nagaon, wherein the numbers of his family members are shown as 9. Above 12 years and 2 numbers below 12 years, but the proceeding has not described regarding 11 members of family members of his father's family. That apart, no any officials from the office of the supply superintendent and Nauga has appeared to prove the genuineness of the document as well as the truthfulness of the contents of the same, and same cannot be relied upon. Moreover, supply card may not be treated as a relevant document for consideration of someone's citizenship. Exhibit B and B1 are the certified copies of electoral roll for the year 1965 and voter details for the year 1966 respectively, whereby the proceeding has claimed that the name of his father is recorded as voter as A. Mannaf, son of Sabet, in respect of village Mahmud Mari, part number 25, Moja Lakwa, PS Rupahiat, district Nogam, Assam, under 19 number Koliabor LSE. Exhibit C is the certified copy of electoral roll for the year 1971, whereby the proceeding has claimed that his name is recorded as Nur Islam, son of A. Manaf, along with his elder brother and sister-in-law, in respect of village Mahmud Mari, PS Rupahiat, Moja Lakwa, district Nogam, Assam, under 19 number Koliabor LSE. Exhibit C1 is a voter details for the year 1971 obtained from the office of the state coordinator of national registration, wherein the name of Nur Islam, son of A. Manaf, is shown to be recorded in respect of village Mahmumari under 19 number Koliabur LSC. Said document is not admissible as a piece of evidence. It is seen from the exhibit B and C that the age of A. Manaf, which projected as the father of the proceeding, is shown as 28 years in the year 1965 in the exhibit B. If the age of said A. Manaf was 28 years in the year 1965, then his age is in the year 1971 would be 34 years. On the other hand, the age of Nur Islam, whose name is claimed as the name of the proceeding, was 25 years in the year 1971, that is in the exhibit D. On the said document, it is seen that the difference of ages between the A. Manaf and Nur Islam is 9 years only, which is not believable, as the difference of ages between a father and his son. Hence, it is established that A. Manaf, son of Abed, whose name is shown to be recorded in the exhibit B and B1, is not the father of Nur Islam. Hold it for a moment, my lord. My lord, these are the two documents. My lord, exhibit B is the, my lord, that certified copy of the electoral roll of 1966, my lord, 1965. And my lord, exhibit 6, exhibit C is the, my lord, voter list of 1971. My lord, in exhibit B, the name of the father only appeared, my lord. My lord, I have annexed that documents, my lord, that.
Why was it rejected?
My lord,
Why was that rejected?
my lord, there is difference in the age. My lord, the father in the year 1965, the age is shown as, my lord, 28 years. In 1965, father age is shown as 28 years. And in 1971,
Which page is that document?
my lord,
Which page is that document?
my lord, page number 27, 27 is the original copy, 26 is type copy, my lord. Page 26. Then my lord, 28, my lord.
Okay.
In page 28, my lord, the father's age is shown as 28, my lord. Page 28.
Okay.
And page 30, my lord, this is the voter list of 1971. My lord, here's the Nur Islam, his age is shown as 25.
Who is Abdul Munna?
My lord, Abdul Manaf is father. My lord.
And who is this? Nur Islam?
Nur Islam is petitioner before Lord Supreme.
Okay. What is your explanation?
Well, the age is, well, there is some discrepancy while recording, my lord. But if, apart from the age, my lord, all the details are, my lord, there, my lord. So only, my lord, since there is some discrepancy in the age, my lord, the tribunal disbelieved that, my lord, the exhibit B.
No, but this is a consistent problem with your documents. Please come to page 56. Nur Islam, father Abdul Munaf, 68 years.
Yes, ma'am. So this is voter list of,
He is the petitioner.
yes, ma'am. This is voter list of 2018. ma'am.
No, it's okay. Rabia Khatun, father Nur Islam, her age is 63. The daughter is 63 when your own age is 68.
Rubia Khatun is, my lord, wife, my lord. My lord, this is a name of the relative, my lord. Sampakya Vyakti Sampurna.
No, in associated relation P, he is Pita.
He is
Hanufa
there,
Khatun Swami Sadek Ali Pita Nur Islam.
but Rubia Khatun is wife.
Where is your written statement?
The written statement is, my lord, page 13, my lord.
30.
13.
13.
So there are two different cases, so two different statements are filed, my lord. So the mainly four documents are there to prove the citizenship, my lord. Exhibit B and B, C and D and H, my lord. My lord, Exhibit D is a sale deed, my lord. The registered sale deed, my lord, that was produced, my lord. And with regard to finding on Exhibit C and D, my lord, Lordship may kindly come to page 70, my lord. Paragraph 11, my lord. The proceeding has deposed that the deed of sale was executed in favor of two numbers of dead persons, which cannot be believed. If it is really done, then it is a fraud done by the proceedee. He has also deposed that the Exhibit D was executed at his 15-16 years of age on 19/4/71. But in Exhibit C, the age of Nur Islam is shown as 25 years in the year 1971. From the aforesaid circumstances, the tribunal is not in a position to believe that Exhibit C is the document of the proceeding. That apart, he had deposed that the Exhibit D was executed at his 15-16 years of age, whereas in the Exhibit D, Nurul Haq and Abdul Qasim are shown as minor, but Nur Islam is not shown as minor. From the said discussion, it is also established that the proceedee was not one of the purchasers of the said deed, that is Exhibit D, is not the document of the proceedee. Accordingly, Exhibit E, F, G are also not proved as the document of the proceeding. My lord, to prove the, my lord, sale deed, my lord, DW2 was examined, who is a person from the sub-registrar office, my lord. He has proved Exhibit D, my lord. That is a registered sale deed, my lord. Exhibit D is a registered sale deed, my lord. So, my lord, the tribunal has discarded mainly on Exhibit C and D on the basis of the deposition of the, my lord, the petitioner, my lord. In his deposition, my lord, he says this sale deed is in the name of four persons, my lord. He says, my lord, while he was at the age about 15-16 years, he has purchased the land, my lord. But he has not said about execution of the sale deed, my lord. So he has purchased, that much he has said, my lord. And with regard to, my lord, yes, one person he says that, my lord, at that time he was not alive. That he has said, my lord, I have asked, he says, my lord, that by mistake he has said, my lord. But that is a registered sale deed, and my lord proved that by calling the witness, my lord. And my lord, Exhibit C only discarded because that since he has stated his age, my lord, on the basis of age stated in his deposition, my lord. Exhibit C is, my lord, voter list of 1971. TW2 matter. That is at page 62. There is some type 62 matter. There is some mistake in translation matter that Lordship may kindly acknowledge. Page 62 originally is at page 63 matter. The Xerox copy. He is from the office of the senior suggestion. Exhibit D mallet. Page mallet 70 mallet. Paragraph 11, subparagraph 2 mallet. And my lord, the exhibit H is the my lord certified copy of Jamabandi. But my lord, that was not believed by the court because my lord, there is new patta number and there is no explanation that my lord, the patta number in the cell deed is converted to new number now. So that's why this was disbelieved, my lord. And my lord, the another thing tribunal takes into consideration that is at page 71, page 14. The place where the notices are served is my lord different than that. My lord, is one namely my lord Majortica. My lord, page 71, paragraph 14. Page 71, paragraph 14. Yes. With that regard, my lord, already there is explanation in the written statement that there is a nearby village and there is cultivation land of the petitioner and his family, my lord. So during the petty time, sometimes they reside there, but all the families residing at the, my lord, the present place where their house is situated, my lord. So that's why the notices are served, and he believed that since his petty fields are there, so that's why he has accepted the notice and appeared before the tribunal. That explanation is there in the written statement. Yes, ma'am. My lord, in his deposition, he has stated that there is no other land than for which the otherwise than the cell deed which is exhibited, my lord. In his deposition before the court, the petitioner has stated that he has no other land except the land for which the cell deed was produced, my lord. My lord, in his deposition, my lord. Page, my lord, 57. My lord. My lord, page 58, my lord. Third line. Fourth line, my lord. Fourth line, I do not have any other land except the land at Vitarputi. Can I be permitted to go through the TCR one? Can I be permitted to go through the TCR one?
May I please, Your Lordship. Lordship, I take kind indulgence, Your Lordship, in item number 21. Your Lordship may not like to take up this matter. Yes, Your Lordship. I'm extremely sorry, Your Lordship, I couldn't mention this morning. Deeply obliged.
With regard to change in patta number, the Jamabandi which was exhibited having the different patta number, although there is no explanation, but tax revenue payment receipts are exhibited, in exhibit number EFNG, patta number is shown as 8, whereas in exhibit number H1, that is at page 49. Originally at 50, the patta number is 63, So it matches with the Jamabandi, And here, the name of the petitioner along with all 3 persons are also there. So this is my case, mainly exhibit B, that is the document of my father, That was rejected on the ground of discrepancy with regard to age difference, Exhibit C is 1971 document of the petitioner, That was rejected because in his deposition, he says that, his age at the time of purchase of the land was 15 to 16 years, And then, exhibit D, that is sale deed. That was rejected because, the 2 persons are shown as minor, So, yes, I am also not shown as minor, But I am not shown as minor, but other two, persons are shown as minor, But they are, sons from my stepmother, Yes, ma'am. Yes, ma'am. Yes, yes. My submission is that, that cannot be a ground because, these 2 sons, these 2 persons are, sons from my stepmother, Abdul Qasim and the petitioner is, from the other mother, So that's why he is not shown as minor, because at that time he was not a minor, Hello? No, I says in his deposition, he says that he purchased the land when he was 15, 16 years old, But the execution of sale deed, he has not said, Purchase, my submission is that, purchase and, execution of sale deed are 2 different things, So he is a illiterate person, that may be something.
Cannot be. That argument is not acceptable. If you see a oral transaction of a property is hit by section 17. So we cannot accept that he purchased the land without it being compulsorily registered under 17(1) to be a good transaction. Doesn't help you anywhere. Section 49 says that transaction cannot be looked into as a bar.
But he says, he has purchased only that much more.
That's okay. Let him be happy with that.
He has not said about execution of sale deed or anything.
But can we take cognizance of that?
No,
That argument is
what
not
he
acceptable.
has stated in his deposition that I'm saying. That is my question.
Yes, Mr. Pine.
Well, the tribunal is right in saying, my lord, that your lordship will find, my learned friend is also agree with that, my lord, that if the Abdul Manaf is the father of the petitioner, whose name was there in 1965, my lord, he was 28 years as per, though it is not clear from the, my lord, page 27, but my learned friend has submitted that he was 28 years in 1965, 66, 65. Then obviously, my lord, the page 31, where the petitioner's name is shown as Nur Islam, my lord, son of A. Mannaf. Is it about 25 years? This cannot be correct. And in WS, my lord, he has not clearly said who is his mother. From where he has said that, my lord, his stepmother is there, and the stepmother's name is Matra. Now, the entire issue, my lord, your lord, my lord, friend was also right, my lord. The evidence and my lord, evidence and my lord, what is pleaded in evidence and my lord, this WS has been contradicted in his oral statement, oral, my lord, deposition while reporting. If your lordship may kindly see page 57, this is totally in contradiction with the WS and evidence.
67,
57, madam,
57. Yes.
where I speak truth. I was born in district of Nagaon, so I do not know the exact date of my birth. He doesn't know his date of birth. My father's name is late Abul Mannan. My father's name is Samartha Bhanu. It is not his mother name. Later I come to know that Samartha Bhanu is my stepmother. Now, I lost my mother when I was young, very young. My grandmother's name is Sabek Ali. I do not know the name of my grandmother. My father, mother, stepmother died when I was 8, 9 years old. Again, man. He contradicting himself. In the first sentence, he said his mother died when he was young. Then he said, my mother, stepmother died. Father, mother, stepmother died when he was 8, 9 years. That means at the same time. After the death of my parents, I came to Butlung village, Tezpur, to my maternal uncle's house. I came here when I was 8 years old. My lord, it is his position. This evidence. I bought some land at Vitor Kuti area when I was 15, 16 years old. It is clear. At present, I am residing in Batakuti village. I have 2 brothers from my stepmother. If my stepmother died at the same time as father, then I don't know, mother, what is their explanation. The 2 brothers from the stepmother, they are Nurul Haq, Abdul Katem. They are also residing in Vitor Kuti village only. I married Rubia Khatun from so-and-so. I do not remember when I married her. At first, I cast my vote in Magurmari village. Yes, then he said, I do not know when I cast vote. In 1971, cast my vote from Vitor Kuti village again. But my lord, his first voter is of 1971. It is of Magurmari village. It is not of Vitor Kuti village. Sonitpur, and from then onwards, I have been casting my vote. My father did not do this vote. So, from this part of the evidence, this is totally in contradiction with the records and the WS and evidence. In WS, he said, in fact, neither in the WS nor in the evidence, he has mentioned the elder brother's name. He has said that in the 1971, my name is listed in the voter list along with my brother. Who is that brother? That is not mentioned. If you also may kindly see the purchase product. You also may kindly see the page 20. This is the WS. Page 20, what he has said, madam. Page 20, madam. There are 9, my lord, it is said that on attaining the use of majority, the name of this ensuring opposite party appears along with his elder brother and sister-in-law in the voter list of 1971. That's so village Magurman. This is of 1971 list. He said in 1917, he was in Tezpur, my lord, he costed vote from Bathikuli village. And his statement.
71 is not Magurmari, it is.
Village Magurmari. Page 9, page 20, para 9.
No, in the evidence.
Yes, in the evidence he said, my lord. It is from, he said, in 1971, I casted vote from Vitor Khuti.
Vitor Khuti.
Yes, but in he has given in evidence, my lord, in WS, he has said in 1971, he was a voter there in Magurmari village. Then he said,
just a moment. Yes.
Then your lordship may kindly say para 10, my lord, what he has stated. This is his pleading. That mother of the opposite party was died during his childhood, and the father has married again Samarthabanu Begum, Samarthaban Begum, who gave birth to sons by Nurul Haq and Abdul Qasim. This is again contradictory to his statement made in page 57, where he said, father, mother, and stepmother died when he was 8-9 years old.
No, that is childhood only.
No, I understood, my lord. Your lordship may kindly see the paratin, my lord. That mother of the opposite party was died. That means after the mother is died, the my lord, father got second marriage.
Okay.
Then he is saying in this para, my lord, in page 57, that all of them died when he was 8-9 years old. No, my lord, after they died, then there is 2 children. My lord, if my mother died in 8 years, My father got married after 8 years. Then there is another 2 children. Then it cannot be on the 8, 9 years in the same year. It can be at least after 5, 2, 3 years. Not on the same time. But he has said, my lord, my father, mother, stepmother, all died in when he was 8, 9 years old. So this is contradicting himself. What he has stated in my lord the place. Why I am saying all these things, my lord? The discrepancies in the age, as well as the, my lord, the place, because in 1971, one Nurul Islam, in 1971, one Nur Islam is a voter in 1971. This Nur Islam, aged about 25 years, is the brother of one A Salam and son of A Mannaf, who was a resident of Magurmare village. Now, my lord, it is not stated anywhere what happened to his brother after 71. After this voter list, he has produced on the voter list of 1989 number, where this brother is not there. This is 1971 voter list, my lord. Now he has to establish, yes, this is the same person. I am the same person who was there in 1971. And this village is Magurmari. Now he is in, my lord, some other village at Tezpur. This is in Nagaon district. This is in Sonitpur district. Some other village in Tezpur. He is trying to link himself that I am that person whose name is there in 1971. That's why this contradiction is very important. Yes, there is, no, he has pleaded that there is sibling mother. He has pleaded after his mother is died, he left to his mother. This fact was not pleaded in the dossier. That after his mother died, he left to my lord Sonitpur and stayed along with his uncles, maternal uncles house. That is not there. In across he has said he has left to this place. And this village, my lord, in cross he said, after the death of my parents, I came to Gutulung village. This is when he has come. How he has come? When he has come, that is not stated. Now in Gutulung village, then he purchased, according to him, he purchased land at Hitorkuti village. Now in Hitorkuti village, my lord, the petitioner and this Asalan, who is projected to be brother, though it is not mentioned clearly in the WS that he has a brother in the name of A Salan, who is, my lord, they are not common voter in Hitorkuti. If your lordship may kindly see, after 1971, the voter list of the petitioner is 1990, is 52. It is Nur Islam Rabia Khatun on a boat of the market. It is in Hitorkuti, Gutlung, Hitorkuti. So 93 also Nur Islam Rabia Khatun. The brothers are not there. Whose name was there in 1971. So we have to establish, he has to establish whether that is the same person whose name was there in 1971 at my lord this Magurmari village. Then there could have been some case to that effect. And these contradictions in his my lord cross, which is against the which are against the the record. Record says something. Record says when he got the land was purchased, he was not minor. There are two minor persons, those who are not minor, but He said, I was 15, 16 years when I purchased the land. Now, whether he is the same person or not, that is the issue, my lord. If he is clear, he could have established that I am the same person. That's why, my lord, the contradiction in his cross has caused the entire damage to the people. BW2 has come, he has said, yes, there is application, there is a land, so that is admitted. There is an agreement, and there is a sale, that is admitted principle. But whether he is the same person who purchased that land, or whether he is the same person or not, that is the issue now. Otherwise, because the identity here, as per the said that he was not minor. But according to this, his said that he was minor when he purchased the land. Because he said, I'm 15, 16 years old. So for all this, my lord, the petitioner has failed to establish that he is the same person whose name was there in 1971, or to link himself to his projected father, whose name was there in 1966 at my lord Magur Manipike. The age discrepancy is clearly proved. And so, my lord, the tribunal has committed no error while passing this opinion. Tribunal has discussed everything on this aspect, my lord. So, my submission is that, my lord, the opinion of the tribunal has not suffered from any error apparent on the face of the record, and he has been given enough opportunity to prove his case, but he failed to establish his case. So, this opinion may not be disturbed. That's all.
That, that wrong is because of my bad habit. Look at this flag, green flag. You see, you have annexed Aadhaar card there. In the, along with your written statement, this was annexure O. Now, in this document, your age, date of birth is 1940. So in 1971, you could not have been a minor. But your deposition says that your parents, your father, mother, and the stepmother died when you were a child. There's a mismatch.
So father is there in 1965. Or in his
Father is there in 65. That's why the entire discrepancy.
my lord, in his written statement, although he has not said his date of birth, but in 2018, age is stated as 68. So it ought to have been 50, my lord.
We don't know. That is your document.
That I have, my lord, that is 1940 is there.
But this is also unbelievable because
Hmm?
around 65, 66, in 66, father is with us.
No, you see, that's why the problem is that
His
when you
father
look
died
into.
when he was 7, 8 years old, my lord. 66 father cannot be there if he is born in 1940. 40
That's why he must have an opportunity to address this. So this is not an exhibited document.
This
It
is not
just
an
came
exhibit.
into our notice because I have a bad habit of keeping papers.
This is not a exhibit.
Let him address it. We'll take it up next week. Take instructions and address it because this will lead to credibility of the submissions of Mr. Payang.
My lord, in page 71, para 14, the tribunal has discussed some extent because, my lord, in both there are two references. There were two references. One in 97, one in 2005. Even after 6 years, his residence is shown in the same village, my lord, at that is Majortica in both the cases.
No, that is quite possible because you see in the village when Mr. Gupta says that the adjacent land is in a different village where they do agriculture. That is quite acceptable. But this we have seen in the field.
And this can be, and even in my lord, summon, my lord, when the summon was served, initially he refused to accept. Then it is written in the backside, my lord. Then the village headman has asked him, then he has accepted, my lord. In the backside, it is written, my lord.
You address us on that. We'll take it up next week.
I don't think that cannot be correct. Even if though he disclosed as per my lord, this evidence, he was 68 years in 2019. So it should be sometime in 1950. Then 8, 9 years from 1950 will be 58, 60, my lord.
So that's why no opportunity.
So that statement cannot be correct.
That's-
His father died, he was
You're very
when
true.
8, 9 years old.
You're true. Mhm. 2013. 2013 of after 2010, any exhibited voter list?
Yes, my lord, 2018, that is at page 55, my lord,
55.
55. Vernacular is at page 56, my lord.
That is 68. 68. Sorry, was what? Yes, it is. नहीं यहाँ पे तो special है You see, this causes a problem again. In 2000, you see, here again, there's a mismatch. If this be correct, 56, then you are 68, and therefore your year of birth would come to 1940, 1950. 50. So again, there is a mismatch. With regard to the death of your parents, that is causes everything. Both sides are represented. The submissions of Mr. A.K. Gupta and counsel to the petitioner remains inconclusive. List again on 6/8/2026.
Published.
Sir, find this, keep a note because we will forget.
Yes.
Yes. There is the age is 68. That will bring the birth of year of the petitioner is 1950.
Yes.
So this fortifies your argument, but they didn't have an opportunity to take instructions and make the submissions.
Published.
Yes.
For admission, item 12.
The issue is, my lord, already there is an opinion, my lord, in 2016 against the petitioner, my lord. Now, the same forum, my lord, in 2025, they have, my lord, held me to be an illegal personality, entered, my lord.
Same person.
Same person, my lord. And, my lord, I have also, my lord, exhibited the earlier opinion.
Where is that?
That is page 66, my lord.
66.
61, my lord, sorry,
61.
61. Bottom, my lord, right at the bottom, exhibit 10 is the certified copy of the order opinion in connection with case number NFT number 3. Next page, my lord, 444/15 dated so, in which OP was declared as not foreigner by the honorable member. Yes, sir. Page 61, my lord. Just bottom line, my lord. Exhibit 10.
May I read first? Exhibit 10. Malab.
How was this dealt with?
Malab, the learned tribunal said, Malab, in that opinion, Malab, the evidentiary value is not there, Malab. Kindly come to page 66, Malab. Page 66, para 16. May I read, Malab? That the OP has stated that in one case being FT, now here, Malab, 44 is written. It should have been 444. 4415, where she was declared as not foreigner. In that reference, no document was proved. And that is the reason why, my lord, the learned tribunal was of the opinion that since no document was proved, my lord, that is not applicable. But whereas, my lord, kindly come to the earlier opinion, page 40.
Sorry,
Annexure D, my lord. Annexure D, my lord. Yes. Page 44, my lord.
yes.
May I read the opinion, my lord? This is a reference against OP so-and-so, the daughter of Sabar Ali, village so-and-so, Assam, as to whether she is a foreigner or not. The FT case has been registered upon reference made by SP Border Nagaon under the Provision of Foreigners Tribunal Order 1964, amended in 1985, with reference to triple criteria under the provisions of Citizenship Amendment Act 1985, to determine whether the above named opposite party entered through India from Israel, East Pakistan, on or after 25th March 1971. It is stated that suspected foreigner Musharam Manikjan, the daughter of Sabar Ali, who alleged to be entered into India, Assam, on or after 25th March 71, without having valid documents. In response to notice, OP appeared before a tribunal and submitted written statement on 16/9/2015, categorically denying the allegation that this OP is an Indian citizen and she has born and brought up at village Batamari, PS Rupoihat district, Nagaon, Assam. That her father's name has been enlisted in the voters list of 65 and 70 of Samuguri LSC of Assam, and she has filed all the relevant documents to prove her Indian citizenship, and hence prayer is to dismiss the reference. In support of her plea, OP Manikjan has examined herself as OPW1, village headman of OP's birthplace as OPW2, and OP's elder brother as OPW3. I have gone through the entire case record along with evidence of OP and all exhibited documents submitted by OP. OPW1 Musharam Manikjan in her evidence has stated that she was born and brought up at village Batamari. OP's grandfather's name is Rabu Sheikh and her parents' name is late Sabar Ali and Musharam Simon Nessa. OP's father's name has been enlisted in the voters list of 65-70 of Samuguri LSC. OP discloses her brothers and sisters' name in her evidence. In her cross-examination, she has stated that father got landed property at 5-6 bighas agricultural land in village, and that her sisters are voter of village but do not have voters identity card. OP herself and her sisters are not yet married and still living together. OPW2 Nurul Amin is village headman of village Batamari, where OP was born and brought up. He has stated that OP's grandfather and father were permanent residents of his village, and he knew him very well. OPW2 has exhibited all the documents of OP, and OP is an illiterate lady. Exhibit 1 is a certificate issued by village headman, that is OPW2, in favor of OP, and Exhibit 1 is his signature. Exhibit 2 and Exhibit 3 are certified copies of voter list of 65 and 70 of 91 Samuguri LSC, where OP's father's name Sabar Ali, son of Rabu Sheikh, has been enlisted by serial number 24, house number 5, part number 56, and serial number 24, house number 5, part number 12 of village Batamari. OPW3 Abu Basar is elder brother of OP Manikjan.
OPW3 has disclosed his father's, grandfather's, and brother's name in his evidence and supported all the facts stated by OPW1. OP's father, grandfather, OPW3 himself, also voters of village, and hence he and her sister Manikjan both are Indian citizens by birth. From the evidences of these three OPWs and documentary evidences, OP able to establish her legacy of her grandfather and father, who have been residing in India prior to 1965, and hence OP is a citizen of India by birth. Accordingly, in the light of above stated facts, I am of the opinion that OP Musharraf Manikjan, daughter of Sabar Alia village Batamari, PS Rupoya, district Nagaon, Assam, is not a foreigner who had entered into India after 25th March 1971. Rather, she is an Indian citizen by birth. So, my lord, this is the position. So, it would be wrong to say, my lord, it was not proved. After Abdul Qudus, my lord, the only thing, my lord, perhaps the learned tribunal has to do, that is also following, my lord, this, there is another judgment of this Honorable High Court, my lord, that is Shital Mandal. Only formality is that, my lord, whether this person is the same person or not, my lord. That has to be identified, my lord. I'm sorry, my lord, I have only one. There are 20 and 21, my lord, of the Abdul Qudus judgment.
This we are aware.
My lord?
This we are aware.
Yes, my lord. And in Shital Mandal case, my lord, para 40.4. In 40 point, may I read, my lord?
Just now.
Yes. Yes, 40.4, may I read?
We have seen that.
Yes. So, my lord, in that view of the matter, my lord, only things remains, my lord, to ascertain the identity of the person only.
Very nice. Two. A2. 40.10. Mr. Payal, 2 days back, I was just reading, I'm unable to recollect that right now. There's a decision of this court by the division bench saying that wherever the opinions are passed without a non-speaking order or without examining the evidence,
Yes.
all those have to be, liberty was granted in the state to reopen. Do you have that order? No.
My lord, there is a judgment, in that case, res judicata may not apply.
No.
That is it.
It's a order of 2020, 4 or 25, where there is a direction by this court that in any cases, those were before that.
My lord, one more fact, my lord. It is a development, my lord. If, this petitioner's name has already been listed in 2019 voter list. Now in 20, she has also been issued Aadhaar card. In 25, my lord, she also casted her vote. So I have annexed her, my lord, voter ID card and Aadhaar card, annexed her H, I, and J, my lord.
petition could not have been discarded like that. You can. किती पाहिलं गीता किती पाहिलं नाही किती काकती असते तेव्हा fine.
My lord, that is true, my lord. The as per the Abdul Quddus, definitely it cannot be done. But so there is judgment of this honorable court also where it is said, if there is no decision, reasoned decision, my lord, the res judicata may not.
No, that would be exactly overruled by Abdul Quddus.
Yes. The Abdul Quddus has.
No, there's a recent judgment. I have read it.
Yes, my
2
lord.
days back only I have read it.
Yes, my lord. I'll get it, my lord. There is a judgment of this honorable court itself. saying that if
In
there is no
25, sometime in 25, last 24, last or 25.
Yes.
Initial part.
Where there
where
is
it has
no
been
written
said
order, we
that.
can challenge that.
Yes.
Yes, that is
Giving liberty to the state to either
I'll
challenge
get
or
it.
further
I'll get
review.
it out, my lord. I'll get it.
Yeah. That will be fine.
The legal effect, my lord, whether it is the same person or not. Once decided it is the same person, then consequence will be. Okay, good, good.
People do not order. Could you remind her? Remind could you? petitioner and so for the respondents. By filing this writ petition under Article 226 of the Constitution of India, the petitioner, namely so has assailed the opinion dated 10/10/2025, page 58, passed by so in corresponding to so by which the petitioner was declared to be a foreigner post 25 to 1973. Next, in view of the order of remand which is proposed to be passed, the court reference from burdening this order with discussion on the pleadings and evidence on record. Next paragraph. It would suffice to mention that in connection with the said proceedings, the petitioner appeared and filed a written statement, and along with her evidence on affidavit, amongst others, the petitioner had exhibited the certified copy of opinion dated
22/2/2016.
22/2/2016, page 44, passed by so-and-so. Passed by the same tribunal, that I so-and-so, in case number so-and-so, police reference number so-and-so, by which the petitioner was declared to be not a foreigner who entered into India after 25/3/1971, rather the learned tribunal opined that she is Indian citizen by birth. Next paragraph. The learned tribunal discarded the said opinion dated 22/2/2016 within bracket exhibit 10 vectors on the ground that in the said reference no document was proved. Full stop. Actually, the said finding recorded in paragraph 16 of the impugned opinion appears to be incorrect because it appears from the contents of the opinion dated 22/2/2016 that the learned tribunal had made reference to a certificate issued by the village headman which was marked as exhibit 1. Exhibit 1, EXT full stop 1. EXT full stop 1. And exhibit 1 within bracket Roman 1 small was the signature of OPW2 in the said case. Full stop. Reference is also made in the said opinion to the voters list of 1965 and 1970. With 1965, you say within bracket exhibit 2, and 1970 within bracket exhibit 3. Full stop. The learned tribunal relied on the evidence of the petitioner who had examined herself as OPW1, village headman within bracket OPW2, and projected elder brother of the petitioner within bracket OPW3. Next para. The learned standing also for the border and FT matters has made his submissions in support of the imperial opinion and it is submitted that the the said opinion dated 22/2/2016 and evidence discussed therein was grossly inadequate to hold the petitioner to be a citizen, and therefore he has supported the finding of the finding an opinion of the learned tribunal dated 10/10/2025, impugned herein. Next para. This court, the Supreme Court of India, in the case of Abdul Quddus, ABDUL, KUDDUS, versus Union of India and others, within bracket 2019, bracket 6 SCC 604, has stated that the principles of res judicata applied on the opinion in respect of the opinion rendered by the foreigners tribunals to stop. Moreover, by following the ratio laid down in the case of Abdul Quddus with bracket Supra, this court in the case of Sital Mandal, SITL Mandal versus Union of India and others, and other connected cases by a common judgment and order dated 28/4/2022, asking WPC 20, but that Sital Mandal, you give a dash and then say WPC 2099 of 2018 and other connected cases. Directed that wherever the proceeding takes a plea of applicability of res judicata on the ground that he or she had been already declared not a foreigner but Indian by foreigners tribunal in earlier proceedings, the tribunal has to take up it as a preliminary issue before going into the merit of the case. And the proceeding in the subsequent proceeding has to show that he is the same person who was proceeded earlier. So stop. Next, therefore, as the principles of res judicata applies in the proceedings of the foreigners tribunals, as laid down by the Supreme Court of India in the case of Abdul Quddus within bracket Supra, and followed by this court in the case of Sital Mandal within bracket Supra, the court is of the considered opinion that the rejection of Exhibit 10 being the opinion passed by the same learned tribunal, page 44 in so and so, cannot be sustained. Resultantly, the impugned opinion dated 10/10/2025, that is page 58, is hereby set aside. Next, the matter is remanded back to the learned member, foreigners tribunal 3rd, Nagaon, Assam, to re-examine Exhibit 10 being the previous opinion referred above. So, however, the said learned tribunal shall now examine as to whether the petitioner is the same person who was earlier proceeded with in FT case number, so also page 44. In the event the petitioner was not the proceeding who was proceeded earlier, it would be open to the learned tribunal to hear the learned counsel for the petitioner and pass a fresh opinion in accordance with law. Next paragraph. It is clarified that say when accept the issue of res judicata, relating to Exhibit 10 of the instant proceedings, the merit of the opinion dated 10/10/2025 on other aspects have not been entered into. Therefore, the said learned tribunal shall pass a fresh opinion without being influenced by anything contained in this order. Next paragraph. The petitioner who is duly represented by learned counsel is directed to appear before the learned member from a foreigners tribunal 3rd, Nagaon, within the outer time limit of 28/8/2026, and by producing a certified copy of the order, await for further orders that may be passed by the said learned tribunal. Next paragraph, the registry shall return back the records tribunal's records expeditiously. Next paragraph. As the order is being passed in the presence of the learned counsel for the petitioner, there would be no requirement of any notice to be served on the petitioner for her appearance in the proceedings.
Malab, till then, Malab, the bail will continue.
You set aside. You need a bail again. You're setting it aside. Other matters would have to be deferred.
I've tried.